Thanks so much for your patience. Let's see if I can. Is this working out or no? Now is it working? Yes. All right. We're all set. Great. And thanks so much for your patience. I think that this is a good metaphor for AI in a way, in that I tried to do too much with these slides, and they defeated 3 USB drives. And so, but luckily we now have figured out a way to get these loaded. So this regulation of AI simulation, this is a project that I am just thrilled to be here to deliver, because I think that there is so much promise in European, Italian approaches to the digital and to AI in this area. And I want to try to outline some of the frontiers of issues raised by simulation. And I'll give you a lot of examples, and I'm going to try to get us a little back on track time-wise as well. So I'm going to go pretty quickly. But I want to also emphasize that at the end, I will have 4 different sets of proposals for how to deal with them. So ask for your patience for something of a thick description of various aspects of AI simulation that I find ethically dubious or problematic. And then we'll get to an application of the 4 new laws of robotics from my 2020 book to this area. So to start with, oops, there's a dream of AI revolution out there now. I had the good fortune of giving this talk 2 days after Saul Khan released a sort of promotional publicity video for both his book and for the use of generative AI in education. And of course, Ethan Mollick's book, Co-Intelligence, is also pushing the idea that this is a brave new form of intelligence that's really going to revolutionize many different aspects of life, including social science, something I'll turn to in my PhD presentation introduction later on today. And in just about any area, any endeavor, you're going to see books like this. And what's particularly fascinating is if you look at the critical perspective of Ben Patrick Williamson on AI in education, he sees this sort of meta field developing of companies commenting on and shaping the field of education research to push it in the direction of generative AI in education, which is interesting. And I mean, certainly there's a lot of resources there and there's a lot of promise. But before we dive in wholeheartedly, I want to give you this scenario, which imagine, you know, a future where we really buy into generative AI in education, okay? Well, that could be a future where students start writing their papers using ChatGPT, but why stop there, right? We could have a counter program to weed out the plagiarized papers, but even if we don't find them, then professors could grade the papers and write comments using ChatGPT, and then education could just become a monetary arms race to buy the best program, right? So you could have the best, students bidding for the best ChatGPT program that could get past the plagiarism detector, professors trying to find ways of commenting that would not strike their students as sufficiently as inauthentic or problematic. And this would be, I think, fundamentally a problem on many levels, but I think one of the ways it's most problematic is it would be a simulation of teaching and learning and not the real thing, right? We'd be going through the motions. We'd be going through the empty rituals. We'd be a bit like Ignazio Salone's priest who lives in the countryside, who no longer believes, but goes through the motions of mass to sort of keep his the villagers happy. But we would be not really doing the real thing, which is exactly analogous to the scenario that Alistair McIntyre begins his book After Virtue, in imagining a future decades or centuries from now where we have fragments of texts of, say, moral codes, of Kant, of 10 Commandments, of other, of Confucian books, but no one has really put them together in a humanly synthesized way. And you may say, well, that's a reductio ad absurdum, but I don't think so. I think actually, and maybe it's not a revelation, but it is something at least where it is a provocative thought experiment to give us a picture of where we may be going. And you know, Kurt Vonnegut's wonderful book, Player Piano, imagines this wholly automated world where eventually, and I don't, spoiler alert, the humans end up sort of tearing down the machines. I have perhaps a vision of a future automation in the movie Wall-E, right, where the machines get smarter and also more compassionate in many ways, and the humans become more indulgent and infantile in that vision. But even if we believe that this is just a reductio ad absurdum and a slippery slope, the implicit teleology of the process can be very revealing, I think. And I want to also connect simulation to dissimulation. This is one of those things where I think that the terms, etymology is so interesting, right? Dissimulation, we clearly know is a term for lying, for faking feelings, or for faking how one is doing. Simulation is the imitation or modeling of a process, and it has a certain duality to it, in that it feels so much like the real thing, but it's not, and what are the problems there? Well, I think one of the interesting aspects of this is to try to connect simulation in AI context to the role of simulation in computational thinking as described by Jeanette Wing in 2006. She notes that computational thinking is using abstraction and decomposition to attack a large complex task. It's a separation of concerns, and it often involves modeling and simulation of a problem, right? But the problem that I see is that in certain areas, it can go too far, and it shows the influence of what Jean-Francois Lyotard calls the inhuman, right? Systems that presume and promote the separability of the body from memory, will, and emotion. I'll give you some concrete examples very soon. One of the problems that I think is really difficult here is, say, simulated prose. Words, strings of words put online that are simulations of what a human would do, but are not actually from a human. Matthew Kirschenbaum, a great digital humanities scholar, has predicted that within a few years, machine-written language may become the norm and human-written prose the exception. We'll have talks about synthetic data later on. We'll be talking more and more about synthetic words. This raises, of course, the problem that's been already recognized in the literature of model collapse, right? Of a future where LLMs stop training on humans' creations, of humans who actually are grappling with and understand the world and have a world model, and it just becomes language models based on other language models based on other language models, drifting further and further away from reality, or from at least a humanly perceived and humanly approachable and accountable reality into a sort of computational dream world. Generative AI is now poised to create profiles on social media sites that post far more than any human can, right? Even if I decided to give up my career in education, and I said, I just want to post online, I want to post as much as I can on Twitter, I could never beat ChatGPT, right? I mean, there have been experiments showing that they can put up 15,000 toxic posts a day from one account, right? You know, I can't do that many. And we can also predict a future where unscrupulous academics and public relations firms may use article generating and submitting software that's already been caught, right? We've already seen on Google Scholar, people do a search for, quote, I am not a person, or I am just a generative AI model, and I think this. That's showing up in academic papers now, actually published academic papers. And so this is yet another problem of the simulated prose. It brings to us the possibility of a spam world, right? Of a world spammed by the creations of LLMs. Clark's World Science Fiction magazine had to close its open submissions because it was receiving too many of these AI-generated stories, right? There's so many stories out there, so you could just type in, please ChatGPT, tell me the story of a lonely robot stranded on Mars that's dreaming of cleaning refrigerators. It'll do that. It'll give you a plausible story, right? And this is problematic because something like Clark's World was a venue for obscure science fiction writers to say, okay, I'll have a chance. And Clark's World could say, all right, as long as they're humanly written stories, probably take somebody at least a couple months to write a story, then we'll take all that on. When you've got spam from people that can write 10 stories a day, no longer can you maintain that humanly accessible process. And my worry also is that law courts are the next to experience spam filings. In a talk I gave in Brussels for the Journal of Cross-Disciplinary Research in Computational Law conference, something I was co-organizing with Maria Hildebrand, I discussed this possibility, and we've seen it in comments on administrative proceedings as well. This is kind of remarkable too. It's even showing up in terms of cultural apprehension, right? So if you searched at one point for Johannes Vermeer, you would get this image. It's kind of like Girl with Pearl Earrings, except they're lantern earrings, right? And you might say, oh, well, who cares? You know, and this is just a strange sort of result that just came up, an anomaly. But imagine, you know, 5, 10, 15 years down the road, people won't even know, you know, what's the difference between Vermeer and sort of AI Vermeer. And I think, again, we're getting from this drift from reality that I think is problematic. And of course, disinformation, misinformation, here it becomes more political, and I think the stakes are even higher, right? There was an image of a burning Pentagon that briefly spread on Twitter and caused stocks to drop. There can be a lot of efforts here in electioneering. Here's the fake image, right? This was just put out there. Again, these are socio-technical systems, right? I mean, if you remember Professor Bertisol's talk, talking about from AI to delegated control systems, these are just sort of like these socio-technical systems, and they are exacerbated when, for example, Twitter/X just sells off blue feeds, right? So Bloomberg is a respected brand in US news. They just sold off Bloomberg feed to some random entity that wanted to spread disinformation, right? And again, remarkably, we're seeing a changing in the valence of, say, progressiveness in IP scholarship here. Because when I was coming up as an intellectual property scholar, and I abandoned that in about 2010 for a while for various reasons, it was always thought, well, trademark law is the rule of corporations trying to oppress other people. But now we live in a world where, say, Twitter could just say, we're not going to respect trademarks, we're not going to respect Bloomberg's trademark, we'll just sell that off to the highest bidder, or sell it off to somebody who gives us $8 a month. And it's creating, again, this problem of disinformation, which is so critical. Again, AI-generated images, the ones in circles are AI-generated, the others are potentially, or actually, maybe they're all AI-generated. I lose track. So, but again, this is something where this was generated by the DeSantis campaign trying to say that Trump was for the vaccine. So, amazingly, that counts as a smear in that primary. And here's yet another image, a deep fake of Trump and black voters, okay? This is not a real image of Donald Trump with black voters in the US, but this is an image that was put out there by many people. And one of the interesting things about this is that many people who defend deep fakes will say, well, everyone recognizes a deep fake, so you don't have to regulate this, right? But what's amazing to me is that at least one interviewee in a news article took this as a real image. He saw it, he said, wow, I guess, yeah, Trump is really making inroads among a community that was very skeptical of him. So then my question is, when you hear people who are anti-paternalistic saying we don't need to regulate this because everyone recognizes it, and they say that being paternalistic is being elitist, who's the real elitist, right? They're sort of assuming that there's this ability to recognize among everyone, in a way sort of condescending to and looking down on those who don't, who I think quite reasonably may say we trust what we see online, or to do that. And of course, there's one, I think it's one more asymmetry in the mobilization of public opinion. There's lots of examples that were being exposed in the New York Times last year of Chinese disinformation, particularly after the Hawaiian fire. There was a lot of disinformation online saying that this was a misguided US energy weapon that caused this. Different Russian attempts to manipulate the elections, described by Nina Jankovic and Peter Singer in their books, How to Lose the Information War and Like War. And what's kind of remarkable too is you have this asymmetry, right? Because in a liberal societies, we have free expression rules that don't really allow for clampdowns. That doesn't exist, say, in many authoritarian regimes. So all of the sort of disinformation, AI-created disinformation, can penetrate into liberal societies. If there was ever any sort of attempted counterattack, that gets cut out. That gets censored immediately, right? And just one other practical example of that, I think at the beginning with either it was Midjourney or one of those AI generators, the only person you could create images of Biden doing terrible things, of Trump doing terrible things, of Macron, of any sort of European politician, et cetera. You could not make that image of President Xi of China, right? You couldn't do that. So again, it's this asymmetry is just, I think, very remarkable, and yet another, I think, crack in the ability of liberal societies to defend, say, social consensus or other issues. We also see a rise of counterfeit people, okay? All of these people are fake, and this was being done in 2020. So even as of 2020, we had the ability in the website, This Person Does Not Exist, to generate these types of images. And this is something where free speech absolutist policies don't really help, right? There's going to be more and more of these types of figures online saying things, promoting different ideas. They're going to look like an actual person is promoting it, and yet there's no person there. And we now have fake news anchors. So these are fake news, these are not real people. These are fake images of persons who deliver different news for Hong Kong Free Press, Wolf News. Choose your own adventure. Choose whatever type of online news outlet you want to say you have. Put it online. You can have people saying this. Now, of course, you might wonder, well, what's the difference, right, between, say, putting out just generalized disinformation as text and having a person behind it? I think there's a huge difference, because if you're a person spreading fake news, like think about Judith Miller attached to the New York Times, spreading disinformation to help accelerate the US's Iraq war, right? That's something that will follow her throughout her journalistic career, right? If one of these fake anchors tells a complete lie about something, then they just create another fake anchor, right? You just get rid of these two people and then pick one of these two people, and then you have millions more, right? So this to me is like yet another huge problem of simulation, of simulated personhood that, you know, we're just not cracking down on, we're not taking seriously enough. I'll also note, and this is sort of building on the wonderful insights and very, I think, deep insights of Professor Ragazio with respect to virtual or AI girlfriends yesterday. The virtual friend, are they really friends, right? A lot of people who think critically about them think they're not really friends, right? When we have sort of an augmented reality persona that's asking you, how was your day? Oh, I hope you feel better, etc. This is just commercial efforts to probe, to get data from you, right? Just as the commercial business model of surveillance capitalism that Zuboff describes can do this by putting ads in front of you and see which ones you click on. This is just a more sophisticated way of saying, oh, I really like your shoes today. What other shoes might you like? And then 3 weeks later, you're gonna see shoe ads like that, right? So we have to really have this deeply critical perspective on this stuff. I think it's not enough, and especially, this is one reason why I joined Beba Berhane and Jelle van Dijk in writing an article that just published last month called Against Robot Rights, Debunking Robot Rights Metaphysically, Ethically, and Legally. Because there are scholars out there who, in the name of an enlightened posthumanism, would say this is the next personhood, right? If someone likes this person, you need to give it rights. But that, I think, is part of a corporate agenda to allow better and more meticulous probing of people's minds to capitalize on that. Right, and what's amazing to me is I think that the ultimate goal of this is a simulation ending consciousness of simulation, okay? So to quote from the social theorist William Bogard in his 1994 book, The Simulation of Surveillance, the goal here of many of these products is the complete total elimination of the gap between the real and illusion, the grandest, highest of illusions, which literally eliminates illusion and transports one to a radically other, but radically same place and time. Okay? That's where it's heading when we think about what many of these entities are designed to do. Again, with this type of advertisement, the AI companion who cares, I believe this is from Replica, you see exactly these types of efforts to say, you know, this is, you can find whoever you want to care for you, and they're gonna care for you in the way that you want most. And this was, of course, I think brilliantly explored in the movie Her. I mean, for anyone that saw that, that's a movie that's about 10 years old. Remarkable how prescient it is. What I find amazing is now that you have a lot of these AI companions sort of simulating human friendship coming out, you get a lot of tech companies saying, wow, this is almost just like Her. And they think that the moral of the story was like, we should create something like this, right? And it reminds me of this terrific tweet from Alex Blackman, who said, you know, and a lot of sci-fi authors will say, in my book, I invented the torment nexus as a cautionary tale. 10 years later, a tech company says, at long last, we have created the torment nexus from classic sci-fi novel, Don't Create the Torment Nexus, right? I mean, it's remarkable. But you know, it shouldn't be surprising because there are multiple quotes online from tech executives saying, who would ever write a book? Any book could be summarized into a paragraph, right? There is sort of an idea of just attacking the very idea of reading or thinking deeply with a book in many of these areas. And again, we have from virtual companion to chatbot lover. There's an article in Euronews about Xiaoai. I mean, again, it keeps pushing forward with this simulation into more and more intimate spheres. So how do we think about this future of fake people, of simulations? Well, I like to think about literature in this way. Okay, I like to explore literature, and this is a quote from Rachel Cusk's trilogy of novels, Transit, Outline, and of course I forget the third, but it's a wonderful, wonderful trilogy. And she describes toward the beginning of Transit, she describes, and I'll just read this because I think it's a wonderful quote, just exploring this. She said, a friend of mine, depressed in the wake of his divorce, had recently admitted that he often felt moved to tears by the concern for his health and well-being, expressed in the phraseology of adverts and food packaging and by automated voices. Quote, he actually felt something akin to love, he said, for the female voice that guided him while he was driving his car, so much more devotedly than his wife ever had, right? So this is yet again another way I think that you have AI outcompeting humans, right? You have something where cheap affection, cheap expressions of concern, analogous to Dietrich Bonhoeffer's theological concept of cheap grace, are going to be littering the human emotional environment and undermining patience with the truly human, right? Again, it's this sort of ecological theme that I would want to develop here, in part inspired by Julie Cohen's recent work on sort of thinking about the ecology of online information, and how so much empirical disinformation research misses the forest for the trees, so deeply. And I think that this is just, we have to think through this sort of scenario. Now, people might say, this is fiction. Why are you bringing up fiction as evidence? But I think it is far more realistic a projection of a potential future than a lot of the scenarios that are released as press releases for firms. I'll also note, I'm developing something called Gresham's Law of Simulated Care based on currencies appreciation, right? When a currency is widely counterfeited, it loses its value. Bad money drives out good. And I think when people are counterfeited, when there are fake people online, again, that's going to drive down the value of real human connection because of the demands they can make, crowding the latter out or outcompeting them in the way that we saw in the hypothetical from Cusk. Now, what are the legal responses to all this? What do we do about all this? Well, I would say one legal response would be based on my first new laws of robotics, which would be that generative AI should complement professionals, not replace them. And that would make chatbot therapists at best an adjunct to therapy, right? So that's one way of dealing with it. And why is this important? Well, because we're moving in some areas in therapy from techno-solutionism to techno-salvation narratives. Ilya Sutskever, who was formerly the chief scientist at OpenAI, said, in the future, once the robustness of our models exceeds some threshold, we will have wildly effective and dirt-cheap AI therapy, right? And I think this is a fascinating goal to sort of put forward as the goal of a lot of these chatbots. There's an idea further that we could overcome the cost disease in services generally. Mark Andreessen has demanded, saying, there are authors that should be writing hundreds of thousands of books now. Okay, so anybody that wrote, say one book in the past 5 years, Mark Andreessen, this financier, says, you are really unproductive, right? You should be writing thousands of them with ChatGPT. Just put in some prompts, you'll get a book today, right? And this is the type of thinking that is going forward now. And what's remarkable to me, I bring up Andreessen because I did some advising sort of at a bit of a remove to some of the legal staff for the National Governors Association of the US, thinking, I've thought about this for 15 years, and it's great that they're calling on me for my expertise. Maybe someday I'll get to speak to the governors. It wasn't me they talked to him. He spoke to the governors, right? So, this is the way in which I feel like the US policy is just drifting toward, these types of almost bizarre claims about the potential future productivity of AI, and I'm very skeptical of it. I think many of the existing chatbots are not ready for prime time. Numerous studies have documented problems with them. And, and I would say that there are analogs, I think, here, and I'll just give a brief story about this image. It may be the case that chatbot therapy is better than nothing. It may be the case that chatbot therapy is better than, say, quick resort to certain forms of SSRIs or other forms of drugs that some people are prescribed when there's some evidence of mental health issues. But it reminds me a bit of this problem that has happened in American nursing homes, where essentially, at first they would restrain the elderly by actually tying them down. Then they would give drugs so elderly residents of nursing homes wouldn't walk off. Eventually, one solution some found is they would put a black carpet, a very deep, dark black, or paint a black hole in front of an elevator, so elderly persons would think that if they went toward the elevator, they would fall into the black hole. Okay, and I think that that's a form of deception, but maybe acceptable in the circumstances. I kept asking. I asked DALL-E, I think, 15 times to develop that image, and it couldn't develop the image, again, because it doesn't have the world model. It just has sort of a language model, so this is all it could do. But I think that's something that we're really on the verge of, is sort of trying to fool people into thinking that they're getting some sort of therapeutic encounter when they are not. It's kind of like the black paint on before the elevator in these nursing homes. A second new law of generative AI, based on the New Laws of Robotics book, is that it should not counterfeit humanity. Carissa Veliz has said that AI should never use emojis, because emojis presume a face, right? If you're using an emoji, it's like you're a person with a face who has some sort of expression. And yet, these language models don't have that. There shouldn't even be the use of I or the rhetoric of selfhood. There's no person in the chatbot, right? It's merely an assemblage. There shouldn't be faking of emotions. And what might this look like in practice? Well, this is from the article Mirages on Anthropomorphism and Dialogue Systems, right? One way of solving the issue is this red image that sort of says, as an AI language model, I don't have physical form, et cetera. But even that's somewhat deceptive, right? I mean, really, we would want it in response to a question like this to say, this generative model does not have a physical form or the ability to experience sensations. This model does not have personal experiences or emotions, right? This, I think, should be a rule for the way these things interface with people, because I think otherwise they're fundamentally deceptive. A third new law of generative AI is that it should not intensify zero-sum arms races, right? We should disclose the use of generative AI to generate legal complaints. We should allow judges and administrative agencies to set those to the side, to put them on a slow track, to process them with generative AI itself. All those sorts of countermeasures should be possible to avoid the spamming of the legal system via this. This is something actually that Cashwell and I published on in 2018 in the Toronto Law Journal, saying that all of this should be disclosed. It should never be undisclosed in the legal system. Limits on tweets and other contributions to online discourse, limitations on entries into writing, art, and other competitions, right? Or have human and AI enhanced tracks. We could do that as well. A fourth new law is attribution, to always have indicating itself as such with ready identification of its creators. This could involve watermarks as well. I know that some people say that watermarks are easily broken. I understand that, but at least we could slow this down. We could make it a little harder, so we could have that sort of attribution. And my conclusion, I think, is going to be, and I know I've gone through this very quickly, but I want to, and I've been a bit negative in this talk. I promise you, my introduction to the PhDs is very positive, so I will balance this out in my 3 o'clock presentation. But I think there's this emerging talk of a right to reality. I prefer the critical formulation, limiting distortions and fakery. But I think in the long term, a program to regulate AI simulation will need to develop a deeper account of the value of the real and the resonant. And the regulation of simulation is one way to preserve those human capacities. And one of the things I find so fascinating is I think just in the work that we're going to see this afternoon, in work on person's sense of identity online and other work like that, I think we're seeing some visions of that next generation of scholarship that will be articulating the value of the real and human values beyond the critical approach that I've given in this talk. So with that, thank you.
You give the floor.
Yes, oh, I'm sorry.
You are also the one who gives the floor.
I also give the floor. Yes, yes, yes. So I will now give the floor. I'm sorry, is it, yeah, is it, let me see who is next on the, sorry about that. I got a bit wrapped up in my presentation. And I now give the floor to Jerry Escolar from the Hague Conference on Private International Law on Private International Law and Developments in Artificial Intelligence. Thank you, Jerry. Yes.
Can I stand there too? Thank you. Frank is obviously a lot taller.
Is it Elettra yet? Oh, it's right there.
It's right here. I have it. Thank you. Thank you very much. Can you all hear me fine? Perfect. Excellent. Do I have to turn it on?
Just speak very
Closely
close.
to it. I will do that.
Try.
All right, can you hear me online? Fantastic. Okay, so if I can hear myself, that's good. Thank you, and thank you very much for having me today. It's always lovely to follow Frank Pasquale, because then I don't have to say anything. We can go outside and enjoy the sunshine. But thank you, and also thank you to the organizers for what has been a tremendous conference. We've heard a lot of very sexy topics, and today I will have to speak about something a little less sexy, I'm afraid, but very concrete. And I think it does follow on all the presentations that came before. So my name is Gérardine Escolar. Today I speak to you as the Deputy Secretary General of the Hague Conference on Private International Law. We'll go into that, it's a long name, what we do and so on, but it's extremely concrete what we're doing. At the same time, because it's relevant to this conference, I'm a full professor and the academic fellow at the Center for Technology, Robotics, AI and the Law at the National University of Singapore. And there we work on these sorts of issues as well from both a public and private law point of view. So today, let me talk first about my organization. The Hague Conference on Private International Law, we call ourselves the HCCH for the acronym in English and French, is specific to the progressive unification of private international law. We are the oldest international organization based in The Hague, and the oldest of three sisters that form a coordinated view towards unification of private law and private international law, and that's together with UNIDROIT, seated actually just about 25 kilometers away in Rome, and UNCITRAL, seated in Vienna, New York. Now, what do we do at the Hague Conference? We specifically look at private international law, And by that, we mean specifically applicable law, the determination thereof, including choice of law, party autonomy. We're going to go back to autonomy in a bit. The question of jurisdiction. Do you get to choose the forum? How do you choose the forum? Is there a connecting factor to certain forums? How would you recognize and enforce these decisions? Because as you just heard just a little while earlier, these online dispute resolution, any kind of judgments or decisions, great on paper to frame and put on the wall if you can't get it recognized. So what do we do there? We try to look at all of this also through the lens of the fourth pillar of private international law, which is really international cooperation mechanisms. So how do we work between jurisdictions, between states, in the structure, the Westphalian structure from 1648 that we have today in the digital economy to get this working? So this is what we do. I'm also concurrently heading one of the divisions at the Hague conference, and we call it the International Commercial, Digital and Financial Law Division. It's a new one. We call it Codify because it's too long otherwise. And we work specifically to facilitate cross-border interactions in civil and commercial matters. So I will not touch on regulation at all. I do believe that Guido Smorto will after this. So no regulation, really just civil and commercial. Why is this important? Because it concerns individuals, businesses, commercial entities, and what it does mean is that it also controls the flow of commerce, money, investment, and the return on that investment and profit. It's one way, basically, to make people liable, to make entities liable across borders for what's happening, and that's how we address vulnerability. So what the Hague Conference does is really just to address human vulnerability, and we're asking now the question, how does that vulnerability translate to the digital environment? And so there we, of course, look at the digital economy. We look at the technological advancements and the growth and uptake in that economy, including with the tokenized economy when that's on a decentralized storage mechanism. So AI, we've heard about this and I won't go a lot into it, but I think it's quite important to also look at the practitioners' classifications of the functions of AI. So we've started from maybe over there, reactive machine, and that was really the easy one, right? The IBM supercomputer that beat our world chess champion. This computer beat our world chess champion. And that's really reactive. So you see one step and the computer makes one. He makes another step, the computer makes another. And then it moves on to limited memory AI, of course. And limited memory AI is something a bit more than Deep Blue. And that really is something that can recall perhaps past events and so on. And it can monitor specific objects and specific situations over time. It can be trained with data. It can improve in performance. And that, of course, you see, there are things like generative AI. And that's actually quite interesting because I think just yesterday there was a very interesting video up about ChatGPT 4.0. Moving so quickly because we have forgotten, but this time 2 years ago, ChatGPT did not exist. It wasn't online, you couldn't have any access to it, 24 months. Why is that important? Because our international organizations don't move so quickly. It takes a lot more than 2 years for the humans around the table, around the globe, to agree on an international framework on what to do with this thing. But this thing came in the last 24 months. Now, what we're looking at is, in particular, multimodality. So when we have seamless integration of video, of text, of pictures, and so on, how do we regulate this sort of thing? Is it an object that matters? Does it matter the control? We heard about delegated control. And this is really important because in terms of digital assets, digital transactions, a lot of the legal minds, very brilliant legal minds, go to subjectivity towards control. So when you delegate that control, or when you heard us yesterday, the delegation of decision-making, what does that mean? What does it mean in relation to party autonomy when we're talking about making contracts? Isn't that a basic, basal human function? And when we delegate that kind of authority, that kind of control to something that autonomously makes that decision, what does that mean in relation to the frameworks that we created for ourselves? So the multimodality is quite important, especially in relation to the transformer architecture that we're seeing in AI. Now, specifically in my talk, I would like to address the matter of tokenization. And what does that mean? That's really a virtual representation of what's happening online. And it's usually stored on these DLTs, right? So this distributed ledger technologies. Could be blockchain, could be some other application. But these DLTs are very interesting because they're distributed in nodes throughout the world, meaning that we start to have a little bit of trouble with connecting them to the man-made laws we had to regulate our societies. And this I'll talk about in a bit of time. So, when we're talking about all this sort of thing, the path to AGI, for example, emotional understanding, an AI girlfriend or boyfriend or so on. And what do we do with that? How do we do something like that? And what do we do in terms of the civil and commercial matters that arise? So that's limited. And of course, the other ones at the bottom are supposedly theoretical. A theory of mind AI and a self-aware AI. And here I'll kind of stop. And in a separate life, I'm a space geek. I really like space things. So really, really love space things. So last year we had this conference in Ferrara where Copernicus was. So today we have to talk about space. I don't know how many of you are aware of this universe called Star Trek. I love it. I'm quite a Trekkie. But there is a whole series called Star Trek Voyager. And the quote is, "Please state the nature of the medical emergency." This is a hologram that is self-aware. It was an emergency hologram that has all of these medical data embedded in this thing. But because Voyager was 70 light years away from Earth, they had to use this hologram as a doctor. So we talked about this a lot, right? I was waiting for this to come up, and it didn't. I have to mention this. So this doctor takes on a human persona. It's an artificial intelligence, and of course, the whole premise was that he had a mobile emitter so he could move around the place, behave like a human being, but he's actually a program, an artificial intelligence, a self-aware one. So on the basis of that and the functions of AI, there's something else that we want to talk about, the offline use of AI. So for example, when you take Alexa offline and it still works, have you tried using, how many of you have iPhones? You have iPhones and turn Siri on and say, "Hey Alexa," have you tried that? It's awesome. I mean, try it. So, we just say, "Hey Alexa," and Siri go, "That's not I'm not Alexa, right?" But what happens if you take that offline? And how does that work? How would you then connect that to the offline use of AI? What if it's an autonomous vehicle and a traffic accident occurs while it's offline? What happens if it's online? Does it matter? And these are the things that we try to answer with private international law. So, what is private international law? As I mentioned, we're really looking at procedural law, so super unsexy, but really sexy because it shows the strengths of our institutions, the strengths in a lot of our institutions in its procedures. So we have certain routes, certain rituals, certain procedures that we use to protect our rights, to protect our societies and communities the way we've built them. And private international law, the way we understand at the HCCH, is applicable law, determination thereof, jurisdiction, so which court, which forum would have jurisdiction, recognition and enforcement of those decisions and awards, and the international cooperation mechanisms. How does this apply to AI? For jurisdiction, in particular, when AI-driven technologies perform acts or take parts in transactions, the online nature of these AI-driven systems give rise to the challenges in determining location. Why does this matter? A lot of the times, we connect jurisdiction to a specific locus. Right, so the situs is really important. And that's actually one of the issues, because if we have something that's online, there's all of these nodes everywhere, and we have things that we've heard about it today. I mean, what if you have like a liminal society? If you have something like that, and the whole thing's all over the world, how do you connect it? Even worse, what if it's on a decentralized ledger, and it's all over the place all the time? So a bit like the Michelle Yeoh movie, but it's all the place, what's it called again? I can't say it right now, but it's all the place, everywhere, all at once, essentially. How would you connect that to one jurisdiction? Can you have lots and lots of parallel proceedings? Do you want that? How does that affect access to justice? And these are the questions that we answer. Of course, another challenge relates to the identification of the type of harm. And that's actually quite important because the type of harm matters when we're looking at which jurisdiction should have, in that sense, the right to decide what happens in that particular dispute. We, of course, have applicable law questions, and when AI-driven technologies perform acts or take part in transactions or make decisions, the online nature of those systems may make traditional connecting factors quite difficult to apply, so we don't know which law applies. Now, we don't know which law applies. That's a serious problem, because that's the first question you ask before you even characterize what this thing is. So you need to know what framework are you talking about. If you don't know the framework, how do we know what to apply? Of course, recognition and enforcement is important. In this case, we already heard about online dispute resolution. And this is quite important because this, and I'll kind of come back to it a little later, the enforcement of foreign judgments may be challenging as a matter of public policy issues as well. We're now seeing more and more the possible use of AI, not just to argue claims and suits, but to write judgments. So instead of having a human judge decide your claim or human arbiter of that claim, that person's is kind of delegating it off to an AI thing to write. So the question is, if you have one jurisdiction that allows that and one that does not, but the assets is in the other jurisdiction, what do? Can you recognize and enforce this thing? What does it mean for online dispute resolution? And of course, then the question, as I mentioned, had to do with connecting factors. And when we talk about connecting factors, it's actually quite simple to kind of look at CITES. A lot of the private international law developments over the last years have moved from domicile nationality towards habitual residence, and to things like governing law and things like citing, the lex sedicitus. It could be modified elective citus, a lot of different things. But how would that interact with an AI-driven system? Does it matter who programmed it? Does it matter where the data is that it's scraping from? And as a large language model, what does this mean? And how would you connect this to a framework of law, to a framework of a jurisdiction of a court that could make that decision? So as I mentioned, when we have a thing, we want to look at it quite concretely, and we want to characterize the type of harm. And we've come up with basically maybe three very big categories. The first one is where the harm can be either real world versus virtual. And this is actually quite interesting because, of course, there might be AI decisions or autonomous decisions taken which would have real-world impact. You've heard one already that Frank just said where there might be misinformation or disinformation online and then the stocks dip, basically. That has a real-world impact. What if an AI that's online creates a traffic accident? That's a real-world harm. But, of course, there are virtual harms too. Things that just happen in immersive technology. So imagine you're wearing these wonderful lenses, these Oculus glasses, you're looking at it, and you're in this extremely immersive world where your avatar is interacting with someone else, and that someone else is an AI. And it creates a feeling of threat or harm, or you're sitting there feeling threatened and afraid. That's virtual harm. How would we protect against that? Is there civil liability? And how do we connect it to the applicable law? The second category is tangibility. And that's, of course, to do with tangible and intangible damage, economic damage, damage to feelings. If my chatbot or companion doesn't like me anymore, it hurts. I like my chatbot to like me, that sort of thing. How does that work, and what does tangibility mean in terms of connecting it to a law that could apply? Then, of course, the causes of harm. Was it because of a design error? Was it because of a coding error? Was it because the data is scraped? Is not good. So we see, of course, quite recently, a lot of move, and we understand this because of IP and copyright, right? So a lot of these big newspapers, all these verified sources saying, wait, I don't want your AI model to be scraping my data because of copyright issues, because I own that information. Fine and good. But then what does the LLM scrape? Bad data. Bad data, that's a serious problem. And so what do we do? So what's the cause of that harm? And we need to consider that as well when we talk about these sort of civil and commercial matters. And we're trying to attribute then a jurisdiction somewhere, applicable law, and how we go about the decisions. And of course, and I will leave that to Guido for a little later, I think. So Professor Smorto, I think, will say, I'll talk about basically regulation. And when we talk about private international law, on top of everything, we also need to consider overriding mandatory regulations. What's the public policy? Are there limits to party autonomy when we're contracting? It's very easy to reduce AI to simply a platform issue. To simply say, well, you accept the terms and conditions of this platform, so it's a contractual thing. Is it though? I wonder. And if it's not simply contractual, then what do we talk about? Is it proprietary? Is it tortious? What are we talking about? And what are the regulations and policies we have to consider? So I want to turn quite quickly to the frameworks that we have right now, because we don't intend to reinvent the wheel. So if something can work, we'll just apply it. If something doesn't work, then we'll work on it, essentially. And this is quite interesting, so forgive me. The framework of this conference is one of three in a wonderful series called Digital Vulnerability in European Private Law. May I suggest that the vulnerability is in the European, simply because while Europe regulates and regulates strongly, digital is not in Europe. It is in Europe, but it's also outside of Europe. And so the European regulations work here. But what happens if you ping something in the USA? Patriot Act applies. What happens if you ping something in China? The moment it gets outside, the moment it's on a digital platform, it's not just in Europe anymore. And so European private law also might want to consider this as a matter of addressing that vulnerability. In any case, at the Hague conference, we have 91 members, including all EU member states and the European Union itself as a member, and members throughout the world. We have two at the moment which we think might apply. I'm not going to go through them in detail. I think I will be hounded to write an article after this, and I will put all of this then in the article to explain it. But we have two conventions. In 71, the Traffic Accidents Convention that might apply for autonomous vehicles, and in 73, the Product Liability Convention, and that has specific applicable law rules that can help decide which framework would apply in those cases in cross-border issues. And because we're talking about European law, you'll be very familiar with this, so I won't go through it. But we have in the European law frameworks, selectively, just some of them here, certain articles and certain frameworks that do talk about extraterritorial application, the choice of law, the applicable law framework, and so on. So I won't go through all that, but that's the list that we're looking at, together with some proposal for directives and so on. So what's the challenges? The first challenge, of course, is the lack of a universal definition. And we just had that conversation outside having coffee. I personally believe that with lawyers, we're using words as tools. And if we're not using the words in the same way, I could be using a sledgehammer while somebody else is really using a precision tool to talk about something. And that's just not a way to work. So precision in terms of definition and words is important, but also in the different languages. So we are a global community and we all speak different languages, and the lack of a universal understanding of what we're speaking is going to be a serious challenge as we try to do cross-border work. Of course, the diverse applications affect characterization, and that's something that we need to consider as well. We, of course, need to consider whether the existing frameworks we have apply. If they do apply, awesome. There's no reason why just because it's AI no longer applies. But on the other hand, does it apply? And issues of localization and connecting factors, of course, together with the lack of consistent global approach. Now, this is quite important. If we lived under one global system where everyone had exactly the same minimum standards internationally and everyone subscribed to the same value sets and the same goals and the same rights and so on, that's fine. But the moment you don't have that anymore, this is something that you need to then kind of have a translated interaction with. And so because of that, private international law is quite special because it does not pretend to deal with the substantive domestic frameworks. What it does is build the bridge between those frameworks to say, okay, look, in this situation, that one applies. In this situation, this one applies. And that's how we allow different frameworks to grow while a minimum standard is being developed. So this is something that's quite interesting. Now, before I go there, I wanted to give you a case study, perhaps. Let's go back a bit, quite quickly. We have quite interesting a case study already in use, and this has to do with health data. So in South Korea, for example, we are aware that they're collecting health data of patients, right? So we just heard yesterday, patients are very happy to share data when it has to do with their own medical history so that they can get treatment and so on. They're happy to also share for academic research in universities and so on. There is a program that allows people to share that data, share their blood work, for example, and so on, and to get a huge amount of that kind of data. What are they doing with that? They then basically say, okay, if your blood work looks like this, your blood looks like the blood of 10,000 other people that have asthma. So do you have asthma? Right? So your blood work looks like the work of 15,000 people that are obese. Are you obese? And they start to make certain patterns based on that. Now that data is being tokenized and sold to pharmaceutical companies and to medical research institutions across the world in token form, which means it sits on the decentralized ledger, but it's data that people give up voluntarily. Then we have this issue then, is there civil liability if something goes wrong? What if that data is leaked? What if the pattern picked out is wrong and a death occurs, right? What happens there? Is there civil liability? What's the law that applies? In particular, if that framework or that trend is picked up by an AI-driven system. So that's one. The other case study is the tokenization of online dispute resolution as well as in-person dispute resolution. And that happens in two ways. You know the Kleros model, which basically gives out tokens, and the more tokens you have, the higher it goes in your soul-bound token so that you have credibility as an arbitrator or a choice, as a choice for a decision maker. That's tokenized as well, and that's kept on your wallet. The more you have, then the higher your reputational score. The other thing basically is third-party funding of arbitration. And what happens is that they take this and basically there's a possible case action, but these people don't have money to fund the arbitration, which can be expensive, so they find a third party willing to fund it. But what they do is they create a DAO, a decentralized autonomous organization. They issue tokens based on that, on the promise that if we win, you get basically what your token represents in terms of the winnings. What does that mean, in particular, if the suit is filed by an AI system? What does it mean if the award is written by an AI system? How does that then link with the recognition and enforcement of that award? Should it be enforced? What if one jurisdiction allows it? It will allow basically regulatory arbitrage, and it will allow choice, forum shopping. And this is something that we want to consider as we go forward in private international law. So I basically stop there, and I'll just leave you with this quote that is not sitting very well in this slide, but it has to do with the implications of justice pluralism, what we call meta-justice, the acceptance that there are different legal orders, and it might equally be justly applied depending on the context. And so, private international law really is a set of tools that order and preserve the existence of diverse norms by minimizing the potential for conflict, regulatory conflict, and other kinds of this sort of procedural conflict. So I'll stop there. That's my contact details if you're interested. And thank you very much for your attention.
Well, thank you so much, Professor Escolar, for a really illuminating presentation. I mean, so much food for thought there in terms of very cutting-edge interactions between law and technology, and I very much look forward to our chance to have a discussion afterwards with such distinguished discussants as well. We will now turn to Professor Guido Smorto from the University of Palermo, speaking on human vulnerability in AI, the risk of risk regulation. Thanks.
Thank you. Thank you, Professor. Thank you, Professor Pasquale. Time is 15 minutes, 10 minutes?
Yes,
How much
yes,
you?
all time, and I'll give you a 5-minute warning. Yeah.
Okay. We have an amazing group of discussants after, so leave the time for the discussion. First of all, thanks to Amalia Diurnia and Claudia Amudio for this organization, but also thanks to the rest of the group, Marta Infantino, the PI of this amazing project, Camilla Crea, Alberto De Franceschi, Luca Perriello, and Loredana Tullio. Thank you for organizing this and for conceiving this project. And also, I would like to apologize for all the PhD students and the young scholars for the afternoon. There is a shuttle that brings us to the airport at 2 p.m., so I will read you in the book once it will be published. So here is the presentation. This is a conventional image we are used to about the AI Act. Now, a pyramid of risk with different levels of risk and obligation proportionate to these levels of risk. So we have unacceptable risk which are prohibited, limited risk that are subject to lighter transparency obligation. Professor Pasquale just mentioned the possibility that we may have more like a right to reality in this case. Low risk that have no obligation other than complying with existing legislation, and the high risk system that must undergo a conformity assessment and a risk management. On the top right, we have the first image. The second image was when ChatGPT was released and another type of risk was added, not exactly where to put it in the pyramid, was added these general purpose AI models with obligations similar to those for high risk system. And on the left, on the right, we also see the new legislative framework, which is the base for this kind of legislation. So an image that give us a sort of intuitive common sense on how to regulate. The higher the risk, the stricter the rule. There are some criticism about this legislation. This is from the New Yorker. Most of that are based on the light touch. So few prohibition with many exceptions, a risk-based approach which is quite weak, based on documents with no licenses, with no temporary bans, with other measures that are typical of risk regulation, the delegation to standardization bodies of regulation, the choice for a cost-benefit analysis instead of the precaution principle, a conformity assessment which is self-assessed by the provider or those people involved in the value chain, and other criticism is that there's a patchwork that put together different kind of legislation. But at the same time, there is a global convergence on the idea, the overall idea, which is regulate AI systems as risk regulation. For example, Alessandro Mantelero mentioned that also Brazil is following this model. Why? For many reasons. The pros are usually listed, so it's future-proof, it's forward-oriented as a kind of regulation, is for not vested interest is more suited. For example, Gérardine Escolar just mentioned a virtual harm, so it's not a vested interest in many legal systems, I would say most legal systems in the world. And for damages, it better deals when there is uncertainty, either on the probability of harm of an event or the magnitude of this event, or it's difficult to prove causation. That tech bodies are better suited to deal with tech issues, and usually this comparison of pros and cons is made in comparison with torts. So torts is less suited to deal with all these features. So we have a global convergence on that. Thing is that we also have to recognize there is a stream of literature in this regard, especially in the United States, I have to say, that consider risk regulation as a value ladder, with many exceptions, of course, but risk regulations as a tool that brings values, that brings choices, normative choices. Let's have a look at that. Considering harms as risk and to be handled, so the idea is that you have a risk, you manage that risk, and the result is that you have a residual risk that if it undergoes the management process, this risk is deemed as acceptable. This means that there are some choices we are making. They make sense, but it's important to discuss it. We have tech solution for normative judgments. It was mentioned in these 2 days. So we adopt a tech solution for something which is normative. We adopt tech solution for harms which are difficult to quantify. Alessandro was talking about fundamental rights, discrimination, fairness. So we're making a few choices. We solve the problem. So what we decide when we have risk regulation is that we accept that risk, we don't ban that, we accept, we handle, we consider the residual risk as acceptable, and we provide solution by making technical solution, even for aspects of our life which are not strictly technical. Someone speak about, I think his techno-solutionism, techno-correctionism is William Boyd, I think, about exactly this attitude, this choice of making technical solution for normative judgments and harms which are difficult to quantify in terms of technical solution. And also there is a lot of disagreement about the empirical assumptions that are at the base of risk regulation, because they are often inconsistent. What I want to focus on within this framework is, since we are here to talk about AI and vulnerabilities, is about risk distribution. As you can see in this picture, the risk can be high for someone, can be medium for someone else, can be low for other people. So the thing is, here we run the risk because by definition, risk regulation is an assessment which is made on aggregate. So we make a cost-benefit analysis as a whole, but most of the time, risk and benefits are often not evenly distributed. And in many cases, they are not only not evenly distributed, but those who bear the higher risk are the most vulnerable ones. And this is true even when the use of AI is good on aggregate. There is also another aspect that may make vulnerable people at risk, which is that this assessment is not only aggregate, it's also standardized. And this is true because tech standard by definition provides standards, but also because in this case, Europe is trying to do something that is to export this solution, is the famous Brussels effect. That means that you cannot put too many, the context into the tech standard. If you want to export a solution across the world, put emphasis on context is not the first thing you do, of course. At the same time, torts, I think tort is a big actor of this regulation. I'm saying why. And the thing is, what is the liability for, of course, not for infringing the regulation, that's different, but for those risks that are acceptable because they have undergo all the procedure. The thing is, liability is not excluded per se. You may still be liable if there is a harm for a system that is lawful, but there are many reasons why it can be difficult to claim in torts. Here is why. First, there are a lot of similarities between fault and risk management. They both deal with risk, with cost, with precaution. So once a system complies with a risk regulation, it's more difficult to assess liability under a fault system. Tech standard can also affect tort litigation through expert evidence. It can be a little different if we have a strict liability regime, but strict liability regime is marginal in this picture, not only because strict liability is an exception to the rule. The European Parliament proposed a few years ago to have a system of strict liability for AI system, but the rule is that you have fault in most sectors where we may employ AI, and also because these are two rules within the AI Act. So it mentioned the unavoidably unsafe product. So even if you have a strict liability for those products that are still unsafe because there's no way to fix the problem, you may not be liable, or the state of scientific and technology. So even in case of strict liability, you have many exceptions to the rule, and assessing liability for acceptable risk is possible in theory, but difficult in practice. I have the last 4 minutes, so I go to automation bias is something we can discuss later. So the over-reliance in AI may exacerbate this problem. Some recommendation, not policy recommendation, because we are before an AI Act. So I will give suggestion within the interpretation of the AI Act. Try to emphasize context. How? To make question, are risks homogeneous? Who bears the risk? The most vulnerable ones? We may, this is something Alessandro mentioned, so I will go quick on that, an assessment of risk that can be contextualized in the impact assessment. It's important to stress the normative question. For example, the Commission may put a specific emphasis when it issues the standardization request to the standardization bodies, Article 40. It's important to stress the risk differentiation and, for example, the distinction of social and individual risk. In this regard, for example, the proposal of directive on AI liability make a reference to high-risk definition from the AI Act. I think this is wrong, because what is high risk on aggregate may be different from what is risky in terms of individuals. So in terms of responsibility, we should make a distinction on that. And how to implement this suggestion in the AI Act. As an example, make reference to to Article 7 when how to amend or add the list of high-risk system by making express reference to those particular group of persons that are affected. We may provide a distributive interpretation of ex-post market requirements. And another aspect is to make use of common specifications which are made by the European Commission instead of the standardization bodies in all those cases where fundamental rights are involved. And the very last suggestion, so to stay within the time, is to consider tort not just as an alternative, as you find in many streams of scholarship, to risk regulation, but instead as a complement. This is especially important when the risk is not homogeneous. When the risk is not homogeneous, torts may be much better than risk regulation. And having torts as a complementary system to risk regulation may help to correct the risk of not considering vulnerability when regulating AI system. Thank you.
Thank you so much, Professor Smorto, and so much food for thought there as well. I have to say that I just found the complementarity of tort and regulation is something that I think that is increasingly a part of the US policy discussion. And I think it is really critical to avoid preemption of tort by regulation, because I think there's such an oppressed by industry there that we really need to watch out for. But I understand that now Professor Bietti is online, and I know that it's 6:30 there, and so I want to be sure to, I'm very, very grateful for being here. And I will just do again, in my spirit of minimalist introductions to bring us back on time. This is Professor Elettra Bietti of Northeastern University presenting on generative AI, competition, and a sustainable internet. So thank you. Oh, and I think we're just, we don't have the sound yet. Sorry, yeah. Sorry, Elettra. Let's see if we have the sound. Fun.
Hi, can you hear me?
I think, Professor Bietti, if I think we may have the sound. Could you try?
Hello, hi. All good? Can you hear me?
We hear you very, very light. So maybe we'll try to turn up the sound.
Sorry, I'm also going to say I can't share my slides yet. Someone needs to make me a host.
Oh, thank you.
I couldn't travel at this moment, so I'm in Boston. My intervention, so first of all, I know that I have 15 minutes. If I go over time or you need to interrupt me, feel free to do so, or let me know that I need to speed up. So I'm gonna step away a little bit from some of the discussions that I've heard coming before me in this panel. And I'm gonna offer a